Chris Hipkins.
Thank you very much, Mr Chair. Mr Chair, this bill amends the Education Act of 1989. The question, of course, is how does it amend the Education Act of 1989, which is dealt with in the substance of the bill? But the wider question is, are there unintended amendments to the Education Act of 1989, and are there flow-on impacts to the wider Act which aren't being adequately considered? Now, the reason I raise this question is the Education Act is a very substantial document, and as a former president of a students' association, I used to have 2 terms, actually. I used to have a copy of the Education Act sitting on my desk. Now, I know it was. Oh, look, it was a. I read it from cover to cover. I can assure Louise Upston, I read it from cover to cover. But I didn't quite go that far. But Mr. Chair, one of the roles of the students' association was to ensure that the institutions complied with all of the requirements of the Education Act and ensured that the students received all of what they were entitled to under the law. So one of the issues that I have with this bill and the way it amends the Education Act is the unintended consequence of that, which is basically it lets the institutions off one of the safeguards that are currently in place to protect students and to protect those attending any sort of tertiary institution by having a strong students' association who can advocate on their behalf. Of course, it makes a number of changes to the Education Act, including around it extends wider than just the membership of Students' Association. It extends to the membership of a tertiary institutions council, for example. So there's changes to the way institutions are going to be governed under this piece of law. So the question, of course, is unintended consequences. Are there unintended consequences of this piece of legislation on the principal act that it amends? And I would argue, Mr Chair, that there are some unintended consequences, and that in fact we need to consider very carefully whether or not the Education Act, whether or not the spirit of the Education Act is being adhered to, whether or not there are other safeguards being put in place to ensure that students' rights are being responsibly adhered to by institutions. I know as a president of the Students' Association, as a member of the University Council, had a few arguments with the Vice-Chancellor and the management of the institution that did go all the way to the University Council, to the governance level of the institution as allowed for under the Education Act. And in fact, in one particular meeting, we won, the Vice-Chancellor lost, because the other members of the University Council, the lay members of the University Council, thought the case that we put forward was sufficiently compelling that they would overturn a decision that the Vice-Chancellor had made with regard to academic grievances, as allowed for in statute in the Education Act. Institutions have to have a process in place for dealing with those. The University Council wasn't satisfied that the Vice-Chancellor had done an adequate job of doing that, and we were able to overturn that. We could do that because under the Education Act there was a universal membership of a students' association which gave us that ability to put forward quite a compelling argument and to argue it all the way through the university system right up to the governance level of that institution. So I think one of the things that this House should be aware of in conclusion, Mr Chair, when it amends the Education Act is whether or not these amendments go wider than what was originally envisaged. And I would argue there's quite possibly a strong, compelling case to suggest that they do.
Joe Goodhue.
I move that the question be now